The executive branch is a mixture of the other two, in my opinion. There is often a hectic pace as problems morph one into the next. Public scrutiny is high, and the chief executive must weigh information, make decisions, sign or veto bills. However, and this is a big however, the amount of time is never the same as it was on the court. The chief executive has less control over the calendar or decision making. Even the best laid plans can be taken off course by an instant change in circumstance or a new crisis that pushes everything else off the table. A flood, wildfire, or health crisis, for example. And yet, sometimes the executive branch moves slowly, even painfully so, because the chief executive sits atop a pyramid of careerists in the bureaucracy, and because rulemaking has taken on the slow and deliberative pace of the judiciary, the wheels of government often seem stuck in the mud. If the legislative branch is known for taking things from the people, and the judiciary is known for being out of touch with the people, the executive branch is known for sheer size and lack of responsiveness. That is something that I am trying to change. Now, one of the things that's unique about being governor is that the governor in the state of Nevada, as probably in most other states does, as I mentioned in my introductory remarks, have the privilege and the ability to appoint new judges in this state. During the time that I have taken office since January, I have already appointed 3 judges. One of those is Judge Tapp, who I'm extremely proud of. We just lost one of our judges in Las Vegas, who is going to Swift Justice. Is that the name of the TV show? So you don't hear that very often. A judge to governor, and then another judge to a TV show. But we are in Nevada. Sometimes the executive is also known for his or her abuse of power. If the legislature had a detractor in Mark Twain, consider this remark from Daniel Webster. The contest for ages has been to rescue liberty from the grasp of executive power. All criticism aside, the beauty of these 3 branches, with their 3 personality types, lies in the very checks and balances our founding fathers conceived. Because they are separate but equal, and because in their separateness they are also distinct in character, tyranny gains no foothold. It really is a wonder to behold, and I can tell you it's a privilege to have lived through all 3 experiences. Because I was a legislator, I think I understand the desire to make rapid change and be representative of both public and party. Because I was a judge, I desire as much information as that can be put before me when I make decisions, and I am more patient than most governors, I think. And because I served in the executive branch before this job, I know full well how the bureaucracy operates, and I'm keenly aware of the public scrutiny that comes with my office. These are my perspectives of how the experience with all 3 branches of government plays out in my current role. Each branch, separate but equal, has unique characteristics that color the exercise of its special powers. I see this most clearly because of my own service, but I know that each of you has similar experiences as you go about your judicial branch work. You can see the differences and similarities in how matters reach you, are disposed of by you, and are implemented by others. How then might you apply my line of thinking of your work to your work as a jurist? When you return home, what might you keep in mind as you interpret and apply the law and carry out the duties of your particular court? For the answers to these questions, I want to spend some time talking about the friction between the branches. You will not engage in the conduct of the judicial branch in a vacuum. Even politics, like it or not, is sometimes a backdrop for what you do. And if you haven't been accused yet of judicial activism, it's only a matter of time. When considering how separate your branch is from, for example, the legislative policy-making rule, you have to think about interpretive powers. Writing in 2009, author Michael Bunger made the case that courts in the United States have always played an important policy-making role through the exercise of judicial review. Bunger focused his thinking not on the well-explored arena of federal courts and their exercise of power, but on the state courts. He writes, "Where the federal courts are largely creatures of statute, exercising judicial powers under the constraints of delegated powers, specific constitutional limitations in the legislative authority of Congress, many state courts enjoy a constitutional level of jurisdictional and structural independence unparalleled in the federal system. The state courts reflect tremendous diversity in their independence, their powers, and their interaction with legislative and executive policy-making powers. The power of state courts is revealed not only in specific grants of authority, but more importantly, in the specific limitations each state's constitution places on the policy-making powers of the legislature. In this context, the three branches of government can be viewed not just as three self-contained silos, but as interdependent agencies of change. The lines are not always clear. Drawing on my own experience again, consider for a moment the job of the State Attorney General. It's an executive branch job, but with judicial branch authority and scope. The same can be said for district attorneys or city attorneys in my state, or state's attorneys in other systems. Neither fish nor fowl, these offices seem to cross between judicial and executive in the way that the Michael Bunger writes about the blurring of frictional lines between legislative and judicial in state court systems. The point is, the lines of separation are not always so clear, and as jurists, you must always remember that fact. Randy Barnett dealt with this same blurring of the proverbial lines in his article entitled "Constitutional Clichés." He writes as follows, quote, "Popular discourse on constitutional interpretation and judicial review tend to employ a series of catchphrases. Phrases such as judicial activism, judicial restraint, strict construction, not legislating from the bench, framers' intent, the dead hand of the past, and stare decisis so dominate commentary on the Constitution and the courts that is quite often all that one hears. In today's political lexicon, judicial activism is an epithet used by political conservatives against what they term liberal judges. The term was actually first used to describe the New Deal court, a Supreme Court divided into two groups deeply rooted in their own ideologies. In this view, one group of judicial activists viewed the courts as, quote, an instrument to achieve desired social results. The second, as an instrument to permit the other branches of government to achieve the results the people want, for better or worse, close quote. Wherever you fall on this spectrum, you're sure to be confronted with the constitutional cliches. You must each find your own bearing, chart your own course as you maintain the separate powers of your office. The lines may blur, friction may occur, but at the end of the day, the power is truly vested in you. In the words of Justice Anton Scalia, quote, "I'm not a strict constructionist, and no one ought to be. A text should not be construed strictly, and it should not be construed leniently. It should be construed reasonably to contain all that it fairly means." Close quote. Trouble is, as I'm sure you can all appreciate, no one is going to tell you what that reasonable answer should be. You will be forced to examine, as I have outlined, the differing temperament of each branch of government and how culture and conduct led to law which you must deconstruct and interpret or apply to the case before you. It's wonderful and challenging work, to be sure. I have to admit, I surely do miss it a little bit. And with just a few days of chaos left in the Nevada legislature, I'm truly missing the quiet of my judicial chambers. I said at the outset that I wanted to give you a picture from my perspective of the differences and similarities between the three branches of government. I also wanted you to pause a moment at the end of your training here at the National Judicial College to reflect on how all three branches may reside from time to time in your judicial duties. I hope I've done both of these things. I'm hopeful also that I've done so in a reasonable period of time. And so I leave you with this tale from the website about.com concerning the one United States President who I've also already invoked, who also served on the United States Supreme Court, William Howard Taft. Popular memory has been unkind to President Taft, 27th President of the United States, who surely would have wished to be remembered for something other than his noble weight at 300 pounds. He was the heaviest commander-in-chief on record. It's the rare biographical sketch that doesn't mention the giant bathtub specially built for him in the White House. Baseball history has accorded him somewhat more dignity, for it was Taft who launched the tradition of the presidential first pitch on opening day. The occasion was a game between the Washington Senators and the Philadelphia Athletics on April 14, 1910 at Griffith Stadium. But legend has it that President Taft started another tradition on that same day quite by accident. As the contest between the Senators and the Athletics wore on, the President reportedly grew more and more uncomfortable in his small wooden chair. By the middle of the 7th inning, he could bear it no longer and stood up to stretch his aching legs. Whereupon everyone else in the stadium, thinking that the President was about to leave, rose to show their respect. A few minutes later, Taft returned to his seat, the crowd followed suit, and the 7th inning stretch was born. Ladies and gentlemen, I'm sure you're ready to stretch your legs as well. So I want to thank you for allowing me the opportunity and great privilege to be here with you this afternoon. It truly is humbling to be sitting before you, judges from throughout the United States, people from all these different states, all of you having to encounter different challenges and different issues. It's fabulous for you to be here at the National Judicial College. Truly, this is something that we are extremely proud of in the state of Nevada. It's unique. I do recall, part of my introduction is that I did indeed attend the Ohio State University, but I do remember clerking for the district attorney's office there and wandering in on one of the errands, the many errands that they sent me on, but into a judge's chamber that had a memento of the National Judicial College here in Reno, Nevada. So I do know that this facility is accorded national respect. So I hope that you are having the experience here that is going to benefit you in all your experiences, and as you return back to your great states, that you'll have great stories to tell about this. So again, Your Honor, I appreciate the privilege to be here. It is an honor to serve as the governor of the state of Nevada. I do, fortunately or unfortunately, have to go back to Carson City now and work with the legislature in these final 13 days so that we can close the budget and get bills passed and go on with our business. So I'll finish with saying God bless you, God bless our great state, and God bless the United States of America, the greatest country on earth. Thank you.